to start it. You just resume it.
There we go. Okay.
Okay, and your recording is in progress too, right?
Yes.
Okay, we're in.
We're in.
Sorry, I'm sitting in my lounge chair. I'm not trying to, because I assume the video is not being used for anything.
Well, Professor Davis, thank you very much for agreeing to this interview. I apologize for the technical difficulties we had yesterday. You've recently had a book published, Freedom Undone, The Assault on Liberal Values and Institutions in Hong Kong. So perhaps we could start with you giving us a brief overview of the book.
Yes, I'll try to keep it simple. Our attempt yesterday, I felt I wasn't very simple. The book has essentially two missions, I think in general. One is to look at the assault on liberal values and institutions as a phenomenon that's part of China's national policies. And it's so much a part of China's policies because the Communist Party tends to view liberal values and institutions as a threat to Communist Party rule. And so the book takes up that line of reasoning, at one point employing a quote from Chow Hong-tong, who says what's happening in Hong Kong is not merely an anomaly, but a warning. So the book should say something to people who are interested perhaps in China and Russia's policies, what these illiberal policies look like in form and how they take shape. And that's the second part of the book. The main part of the book, of course, the largest part of the text, is to talk about what happened in Hong Kong and to go into the weeds, to look at some detail in how these illiberal, I should say this illiberal turn has taken shape and what it has meant in Hong Kong for people there. The book otherwise gives a narrative history of what happened in Hong Kong from the handover, looking at the interaction between Hong Kong people and both the mainland government and the Hong Kong government, and how various guarantees, and I argue in the book that you can't really understand the Sino-British Treaty or the Basic Law except as a guarantee of liberal institutions in Hong Kong. And how those institutions at times appeared at risk, and how the people of Hong Kong, in their wisdom, understood that and promoted the promised democracy because they thought a government that was more directly answerable to the Hong Kong people would be better at working with Beijing to guard Hong Kong's core values and so on. So that's kind of a very quick snapshot of what I do in the book. It goes through all the period from the handover, various chapters, as you know, get into different periods and what happened and the reasons for protest and the government's response, a kind of dialogue between the people and the Hong Kong government and sometimes the Beijing government over 20 plus years. And of course, then getting finally, and I'll stop my answer to your question here, getting finally to the national security law and then the so-called patriotic elections that were imposed, and then at least mention of the Article 23 legislation, speculating about its content in some parts of the book, but also having actually the last day before launch a chance to include a large paragraph in there about the consultation document on Article 23. So getting very much into predicting that and predicting the outcome of various cases, so on, in terms of what was happening with them. Of course, we've had some cases this week come to resolution.
We'll come back to some of the more recent developments in a little bit, but one of the major themes of the book, and it's one that you mentioned just now, is this downward spiral in which Beijing's mistrust of Hong Kong leads to heavy-handed intervention that in turn generates public and pan-democratic pushback, that itself creates yet more mistrust on the part of Beijing. And there's this repeated cycle of this that we see over the past 20 odd years. Was there ever a point, looking back, when that cycle could have been broken?
I think early on it could have. It would not really have gotten that much started. And we know very early on there was a right of abode case, and at that point the courts ruled that the applicants had a right to live in Hong Kong, and the government didn't like it, and the government went around the Hong Kong government. The Hong Kong courts, excuse me, went around them to Beijing to get an interpretation. So at that moment, the government is taking an effort to control what the courts do and so on. And of course, this was a big news item in Hong Kong, and caused a lot of concern that the rule of law would be under threat. And I think so that was just the starting gate of sort of applying the basic law, and it didn't go well. And then we know the government next sort of most prominently tried to impose Article 23 legislation. And it had a draft legislation, and several of us, I was actually one of the Article 23 concerned group members, we sat down and looked at the consultation materials that were available at the time in terms of what the government's legislation would be, and we were concerned about it. So the spirit of the signing of the British Joint Declaration of Basic Law was to maintain a liberal order in Hong Kong. So any sort of diminution of that through increased police powers or oversight and so on of organizations and things like that were in that law, much less than what would later be imposed on Hong Kong under Article 23. But at the time, in a liberal open society, one of the most liberal and open societies in the world, that there was concern about it. And we all know from history that that our efforts and our pamphlets that we released on the street of Hong Kong led eventually to protest. And again, so the government had to back down that time, but it had alerted the Hong Kong people very much that democracy would be important if we're going to have a government that's sort of on the side of Hong Kong people and not Beijing, and guarding the commitments under the basic law. So that, I think at that juncture, if the government had taken a different direction, we probably would not have seen. We would have seen an Article 23 bill that was reform-oriented, that was progressive and geared towards maintaining Hong Kong's human rights and freedoms and so on. We didn't see that. And so these two events both sort of signaled that the government would be taking a harder stance. And so in 2004, when Hong Kong people took to the streets to demand democracy, a very large protest again, as there was in 2003, that the government, of course, did not give in. And Beijing, of course, controlled that. So it became evident at that point that this tension was there. And as you say, then, and as I discuss in the book, we get this pattern of the people speaking and the government responding that repeats itself several times then.
And a couple of things you touched on in that answer are limits that, or kill switches, if you like, that were baked into the basic law. There were limits on judicial authority in the form of the National People's Congress Standing Committee having the power to interpret the basic law. And there were limits on the pace and scope of democratic reform. Despite those rather significant limits, when you ask in the title of chapter 3 whether the basic law is an enlightened commitment or a ruse, you seem to still think it was an enlightened commitment, and that there was at least some sort of desire to make good on the more enlightened provisions. Why is that?
Yeah, I think that in those days there was still this sort of residue of of reform in China, and that had been launched by Deng Xiaoping and was part of all this process. The Hong Kong agreements being very much a part of that agenda, being one of the sort of primary concerns that China had at the time. So they're developed, and I was very much involved in the public debates at the time. They're developed a kind of sense that, well, there are two basic flaws in the basic law. One is the judicial review element, which I discuss in the book and you just mentioned. The other was these democratic reform sort of foot dragging, the government invoking something it called gradual and orderly progress, which essentially meant no progress. So these two things were there, but the idea sort of developed, well, there should be some progress. Let's be patient. Hong Kong people were willing to be, I think, to a certain extent, patient about the democratic reform. And on the rule of law element, I think there was a sense that, well, if the Hong Kong government shows more restraint, which it had not shown in the right of abode case, but if it shows more restraint, and Beijing also is somewhat restrained, so there are not many occasions for interpretation of the basic law, then that system, that liberal order in Hong Kong that's otherwise provided in the basic law, would be able to survive. Now, maybe this is wishful thinking on hindsight, but at the time in the reform era that we were in for China, there was still question about what reform meant to China. Was it just economic? Would it be some more law-oriented, political, or whatever? And in Hong Kong, I think there, perhaps with no real choice to do otherwise, that there was an urge to be hopeful and hope that Beijing would show restraint and the Hong Kong government would find its voice to represent Hong Kong people. Neither of those ultimately proved to be the case, but that was the feeling at the time.
One of the more curious parallels that comes up in the book early on is this idea that one country, two systems was modeled on the 17-article agreement under which China took control of Tibet. And when we spoke yesterday, you briefly also referred to Tibet. It's interesting, the journalist Cheung wrote something for Radio Free Asia, where he said that round about the time the joint declaration was being agreed, he was told by a senior former Chinese spy in Hong Kong to pay close attention to the 17 Tibetan articles, perhaps in a hint that he should not be overly optimistic about the future of Hong Kong. So perhaps you could say a little bit more about what you see as being the parallels between the Hong Kong arrangement and the Tibetan arrangement.
Yeah, well, in the Tibetan arrangement, the commitment wasn't to a liberal constitutional order, but rather to the continuance of governance by the Tibetans themselves. And of course, that proved a rather futile wish, I guess. I have had many occasions to work with Tibetans in exile on, trying to understand Chinese policies towards Tibet. But at the time, there was, in those early years, there was actually a move within Tibetan exile community in its efforts to negotiate with Beijing, a move to try to get something like the one country, two systems model in the Sino-British Treaty to apply to sort of in a renewed fashion to Tibet. So the Tibetans had this early 17-point agreement that more or less promised the Dalai Lama would continue to rule and so on. And it fell apart largely because it didn't have the sort of it didn't block mainland Chinese interference. Now, the basic law has articles in it that does say that mainland departments are not to interfere in Hong Kong and so on. where the 17-point agreement sort of got swamped by Chinese mainland officials, maybe in the zeal of the era when China was Communist Party rule was being established, interfering constantly in Tibetan affairs to the point where it became intolerable and the Dalai Lama fled into exile. So yes, if you think of the 17-point agreement as a precursor, it represented kind of a threat that the same would happen in Hong Kong, which seems to be where it's at now. But of course, that didn't happen for 20 years. And Tibetans, in many of their, they even had their own, I'm trying to remember the title of it, but the title of a document they produced in 2008 in response to efforts to talk to mainland leaders. And they tried to inspire something akin to what Hong Kong has, actually even a more limited sense than Hong Kong has, because they didn't have imagined they could get this full liberal constitutional order. In any case, so there's been this kind of interaction with that. And we all know now that the autonomy, the so-called special autonomous regions in mainland China, have virtually no autonomy at all. Rather, the ones in the periphery regions are more under control of the central government than ordinary areas like Shanghai and elsewhere. So we know that China has used this autonomy concept more as a national security concept to control those regions which they view as threatening, maybe separatism and so on. And so now Hong Kong has kind of entered into that category. So one of the questions we could ask, many people ask, is Hong Kong becoming another mainland city? Maybe worse. It could be becoming another region that's like those peripheral regions of Xinjiang and Tibet, because it has the same ingredient of some causing some concern on the central government about national security. So we don't know the answer to that question, but it starts to look a bit like that at present.
I mean, one of the things that I used to say about one country, two systems is that there's more than one mode of failure. Mm-hmm. It's not true that the only mode of failure is Hong Kong ends up looking like any other mainland city. There were supposed to be specific commitments as to what the second system looked like. Mm-hmm. Although now, of course, that seems to have become moot in light of the 2020 NSL and its aftermath. Mm-hmm. So I want to talk a bit more about the NSL and its aftermath now. Why do you think the 2020 crackdown has been so effective? And what elements of the crackdown stand out to you in particular?
Well, that is, of course, one of the big missions of the book. And 3 chapters go into this at great length. It is absolutely comprehensive. I think that's one element that really stands out. It virtually disregards any reasonable interpretation of what the basic law would have required in regard to Hong Kong's autonomy. That's more or less thrown out the window with this. And I think what it does is it largely, already in 2020, imports the mainland national security regime to Hong Kong. We know by the time we get to this year and the imposition of Article 23 legislation, that the government in the consultation document, openly embraces the mainland national security regime under the label of a holistic approach, which it describes at some length in the consultation materials for the Article 23 legislation. So that's not ambiguous, but really 2020, that was essentially done. And so, and why it's so effective is obviously because people get arrested. I think one element is that. The other is that, and so people, there's a kind of warning, and I would add to that one of the effectiveness elements is that it's unclear what is prohibited and what is not. And so that requires people who don't want to risk arrest to make wide berth for national security. So that's sort of in the background. But I think what it also does is it provides all the tools that are needed to control opposition in Hong Kong, just literally. It involves it's imposed without consultation on Hong Kong. Let me see, I want to take a quick glance at my note of where I'm missing here. Yeah, so it can be more efficient this way. You can edit that a little bit if you will. So it's imposed unseen. It's superior to all local laws. It's an illegal amendment of the basic law. It's not subject to constitutional judicial review. It has a select panel of judges who we saw operating this week in regard to the 47 case. And then I think most importantly, it has a local committee on safeguarding national security whose behavior is not subject to judicial review. And so the result is that the whole national security apparatus imposed under the law can be done in the dark, in shadows, only with us only hearing about it when someone's finally arrested or something of this nature. And then added to that is an Office for Safeguarding National Security, lest there be a lack of expertise in imposing the mainland national security regime. This office is staffed with mainland public security and state security officials. So it's just the utter comprehensiveness of it that makes it, I think, very dangerous for anybody to speak out. And then it doesn't stop there. It doesn't. We're often reading in the news about the criminal justice elements, and they're important. So it degrades in many ways the common law approach by taking away people's presumption in favor of bail and making it kind of a presumption against it. It creates special judges a select panel of judges who hear cases, as we see again this week, and denies the right to a jury. So this panel replaces a jury. So very fundamental ingredients of the common law protections and of due process and so on are taken away. So all of that is done. And then we add to it, it tries to transform the society by targeting the media, and in particular, RTHK, one of the most prominent public broadcasters, is now given guidelines that control and affect what it can report on and how it reports. So that has a big impact on the information in the society. And then it tries to change people's minds through education by controlling and imposing all kinds of guidelines that would silence students. They face risk. Teachers face risk if they don't adhere to all of this. So I think all of that put together is just comprehensive. And it's like a textbook on how to suppress an open society. And that's why the warning notion is very important, because it's not just, railing against, like Donald Trump does, perhaps, against this or that, but rather providing absolute replacement of all the liberal institutions that were there, or transforming them to a point where they're unrecognizable. And that, I think, is why we have silence in Hong Kong.
I just add to that on the point of your point on the vagueness of the NSL being a feature and not a bug reminds me of Harry Link's now very old article, The Anaconda in the Chandelier, where his point was precisely that the mainland criminal justice system derives its power from its vagueness. So there we get it.
Yeah, it's bizarre, a combination of vagueness on the one hand and comprehensiveness on the other. So the language is vague, but the tools in the government's hand to suppress you are comprehensive. The Office for Safeguarding National Security isn't even subject to local jurisdiction. let alone judicial review. So all the safeguards. So when the government now wants to say, well, every country has national security laws, well, every country has them. They may not be so vague, but even if they are vague, they're subject to the limitations in a democracy of rights guarantees and so on, and the institutional tools to protect rights and due process of law. When you take that away, it doesn't matter what the language is, you don't have rights.
You bring up an interesting point there in terms of the use of comparisons, the strategic use of comparisons by officials, and I would suggest by judges, where on the one hand you have Hong Kong officials trying to defend the NSL and now the Safeguarding National Security Ordinance, the Article 23 legislation, by saying, oh, well, every jurisdiction has national security legislation. But on the other, as you point out in your book, there are judgments where counsel have tried to argue that, for instance, as a matter of common law, sedition has these required elements as to intention to incite disorder or some sort of violent uprising. Yeah. And the response there is no, that there are unique conditions in Hong Kong that mean that these other precedents from the rest of the common law world don't apply. So there's a sort of very interesting schizophrenia that's happening in terms of the use of comparisons between jurisdictions. And I wondered if you could say a little bit more about how you think comparative law is being used and abused as part of that process.
Right. So officials, of course, for them, most recently, of course, in the draft of the Article 23 legislation, saying, well, the UK and Australia and Singapore or wherever has similar laws. Well, the question I already raised is whether they have the institutions to guarantee that the laws function in a way that protects rights and due process. So that's the failure of their argument. But with the judges, it's interesting to me. I just read this 300-page opinion. I didn't read it in detail; it was too long. But 300-page opinion verdict on the remaining defendants in the 47 case. And not once is the word human rights mentioned. Not a single mention of human rights. And so you were just talking about the violence and stuff. These are principles. We actually wrote them. I wrote them personally in one of the pamphlets, because I wrote one of the pamphlets in 2003 for the protests, so-called rainbow pamphlets. And I cited the Johannesburg principles, that a speaker must intend imminent unlawful action. Actually, it says imminent violence, or imminent violence must be likely to occur. In common law cases like the U.S. case, Brandenburg versus Ohio, it says imminent unlawful action, that they intend imminent unlawful action and that it be likely to occur. But this kind of language now is dismissed. They said, in effect, these standards in the Johannesburg principles and the Syracuse principles are outdated. And then they invoke something called exception, that Hong Kong's an exception. I mean, if anybody knows anything about history, we know that the purveyors of the terror in France over 200 years ago talked about exceptional justice as well. So exceptional justice has a very checkered history. That, this is the tool of an autocrat when they want to repress the people. And it's sad to hear that use by our courts in Hong Kong, because the Hong Kong courts have largely been very respected. And of course, I suppose this is why the national security law in 2020 that Beijing required that there be select judges, because the Beijing obviously didn't trust all Hong Kong judges to go along with what Beijing wants in regard to how this national security law or similar laws regarding national security are applied in Hong Kong. So select judges, and then they have a provision to dismiss them from the select list. Of course, they don't tell us with the select list who's on the list even. So only we get that from watching cases. So this distrust of the judges has inspired, I suppose, select judges to be more accommodating in this language and trying to argue out of the common law practice.
Speaking of the illiberal turn in recent judgments, I mean, did this happen? Did this happen overnight? Did this only really begin with the imposition of the NSL, or were there rumblings of this sort of illiberal turn beforehand with things like the express rail judgment?
Yes, I think what you have, I remember long ago when I was a student at Yale Law School, an argument was made that judges are people too, just like there was a store in those days called Toys R Us. Well, judges are us too, and they have a finger and they can stick in their mouth and feel which way the wind is blowing and try to accommodate the pressure that represents. And a good judge will try his best to be conscious of society and the forces going on in society and not dismiss them entirely, but to try to safeguard fundamental needs of society at the same time in the rule of law. So this is called legal realism, as you know. So this kind of the influence of power and those in power and the society at large on the judiciary is something that's recognized. And so I think as the government in Hong Kong and Beijing became more and more intrusive in Hong Kong, we would see some efforts by the judiciary to accommodate that. And some limited amount of that is okay because there's some need to safeguard their position. If they go too aggressively against an autocratic regime, they might be slapped down. So you can understand that they do feel that pressure. But I think that pressure increased dramatically with the imposition of the national security law. And really, even in 2019, when they were, I think it was several defendants were already in the court from the previous protest, and the government was appealing the more moderate view that the judges had taken in Joshua Wong and others' case. There was an appeal, and that was kind of overturned ultimately at the Court of Final Appeal, if my memory is correct, and it's in the book, I go into this, where they accepted a standard the appeals court invoked, but said they could not apply it retroactively. So this is the judges navigating that space between those in power and basic rights. I think what we see after this, once the national security law is imposed, is much less of this effort to still maintain certain principles within this context.
To return to the more recent illiberal judgment, the case about the 16 members of the Hong Kong 47 who pleaded not guilty, how do the Hong Kong 47 fit into the broader story you tell? You know, I know there's a chapter where you talk about the gutting of electoral arrangements for the legislature and district council, but how specifically does the primary case fit into this bigger picture?
Well, it's an interesting paradox, actually. There's a kind of irony in the final outcome of that case, if we can start there, in that these people who conduct a primary, which is under the guarantees in the basic law, should be perfectly legal, It's a way to select the better candidates, so within a camp where there's too much competition within the opposition camp. So there's a very sensible thing, and it's an effort to do that. And there's nothing that in the law that prohibited that. In fact, it's a common practice in democracies. So they're doing that. And then they have a goal to push the government to adopt these 5 principles from the 2019 protest, which are themselves also very legal in Hong Kong. It's allowed. There's nothing illegal about investigating police behavior or releasing people that have been arrested and so on, or carrying out the promised universal suffrage with the 5th demand. All of that stuff is perfectly legal, what they're demanding. And then they orchestrate a plan to put pressure on the government to do that by using another article in the Basic Law, which says that if the budget is rejected, that there's a process where eventually the chief executive could be forced to resign after an election is held and so on. I don't want to get into all the details of that, so that's where they are. And then it's interesting. I found an irony in that verdict the other day, in that the government, which has actually undermined the independence of the judiciary, totally changed the legislative council, so its independence is also degraded, is prosecuting people who are actually using the legal structures to achieve a political aim, which is perfectly legal in Hong Kong. So that's kind of the position it's in. And in the iron, I suppose no one is going to miss this irony, that the people who are actually overthrew the existing constitutional order are the ones prosecuting people who were trying to sustain it. So that I think is where I put this case. And of course, there's a chapter there that talks about the patriotic election regime, and how it has all these different elements that essentially block any opposition candidate, genuine opposition candidate, from even running for the office through all this vetting process and so on. So this goes into that and how it works to effectively assure only people who support the government's policies, not just support the government in a vague sense, but literally have to support all of this stuff, or they're not going to be able to clear all the hurdles to run and be in the legislature. So this is why I'm saying they've essentially overthrew in the national security law. They overthrew the regime for legal processes when national security cases, and then they subsequently overthrow the constitutional legislative regime, and now they put the courts under severe strain. So one wonders who's guilty here. But unfortunately, the result is going to be, I think, severe for these defendants.
Turning to another recent judgment, and you mentioned the earlier judgment in the book where the Court of First Instance refused to grant an injunction against the dissemination of glory to Hong Kong on online platforms, including YouTube. And one of the reasons the court gives was, well, the government already has all these criminal law powers. Why on earth is it seeking an injunction? Right. And the Court of Appeal overturned that refusal and granted the injunction. Does that surprise you? And what does it portend for critical expression online?
Right. Well, it doesn't surprise me. I mean, what we're talking about here is something that is especially guarded against when it comes to free speech law, and that's prior restraint. That free speech is not absolute, and there are restrictions, and people can be punished for under laws that pass the test, in terms of protecting basic freedoms. But prior restraint is something that has always been an anathema for courts in dealing with free speech. So the Court of Appeals original ruling made a lot of sense. But I think the Court of Final Appeal, of course, goes where the government wants it to go for the very reasons we've already discussed, with all the pressure on the courts. You know, there's an urge to accommodate the government, especially in the area of national security. Even in the cases of prosecution, if the government brands something a national security matter, then it seems the court just accepts that. So that's why we hardly see any reference to free expression at all in cases which around the common law world always involve free expression. So that's kind of where it's at. And it doesn't surprise me, but what it does, it sort of gives government clearance, I think, to target other publishers of information. And in this age of social media, there are all sorts of publishers of that type, which are vulnerable now. Certainly, this also, in combination with the new Article 23 legislation in relation to surveillance, I think puts pretty much social media at risk in Hong Kong in ways that it had never been before.
Speaking of Article 23 national security legislation, you do refer in your book to the consultation document, and the legislation since passed in record time, and it was used just days ago to arrest Tung again and 6 others for posting allegedly seditious messages in the run-up to June the 4th. So you've mentioned being in the original Article 23 concern group. So first of all, can you just sort of give us a flavor of how far apart the old and new legislative proposals were? And then perhaps you could go on to say a bit more about how the new legislation affects the overall assessment you give in your book.
Yeah, well, right. And I would say to the first part of your question, the differences are breathtaking. I mean, it's the original proposals were defective, came up short in an era where, and at a time where there was a commitment to basic freedoms in Hong Kong, okay? A very strong commitment. The government was under pressure to sustain that commitment, to inspire confidence in Hong Kong, both locally and internationally. And so the things we fussed about more police powers, some limitations on organizations, and a few other things, were in the context where the bill should have been a reform-oriented bill, because Hong Kong already had laws on a lot of the topics that are covered by Article 23. These colonial laws that were themselves not very, they're somewhat draconian in their content, regulating in relation to sedition, just inspiring hatred and things like that. But the colonial laws in the age of the Bill of Rights, simply like the sedition law, were not used. They just ceased to be used, as is common in a common law jurisdiction. When you have old laws that are really not going to withstand constitutional scrutiny, you just don't use them. Sometimes they remain on the books. If they attempt to use them, then they can be stricken. But nonetheless, those laws existed, and the expectation at the time was that Article 23 legislation would be reform-oriented, up to date in the context, and adherent to international standards and the guarantees made in the basic law. So all as applied in the common law. So all of that was the expectation, and that was the shortfall. The new stuff is just way, way, way beyond all of that. It seems like a comprehensive effort to ratchet up punishment, I think, for things like sedition, and so on. It adds a number of other crimes, but there's little or no regard for basic freedoms in this new model. So it's not a context of an open society attempting to provide national security legislation, but something very much in the mode of an autocratic regime. As I highlight in the book, the consultation document already told us where they were headed, and they were headed towards adopting really the mainland national security regime, which they praise in the first chapter of the consultation document. And the mainland regime is one that's oriented towards internally, towards regulating the Chinese people. The mainland leaders have read the political economy literature, and they know that when a society develops to a certain stage, people will start demanding greater freedoms and the rule of law. And so their national security regime, which targets 20-some different areas of society as areas of concern to be monitored and watched, is very much oriented towards making sure the Chinese people themselves do not overthrow the Communist Party. So it's a regime to protect Communist Party rule. Well, the Hong Kong consultation makes explicit that it admires that mainland approach, and its so-called comprehensive national security concept is adopted under the name holistic approach. And that's what's in this new Article 23 legislation. By the time the consultation document was issued, we knew where it was headed. So that embrace, I think, is the defining characteristic of it. It's very expansive in terms of state secrets. For example, mainland state secrets, really anybody who comments on official policy in the mainland risk intruding on state secrets. And everybody is a guardian of state secrets. In most common law practice, it's imagined that officials have secrets and they're not supposed to reveal them. But on the mainland, if I dig up something that's going on officially, even if it's just economic or social welfare policy, then it could be a state secret and I could face arrest and punishment. So that's now adopted to Hong Kong, specifically citing these areas of social and economic development. It has some concepts of espionage, and this includes a whole wide range of things. So it's one of the things about the new Article 23 legislation is it's trying to, in addition to regulating people in Hong Kong, it's very targeted at foreign interference in any form, okay? And one form of that might be something called espionage, which is defined, and I quote, obtaining, collecting, recording, producing, or possessing or communicating to any person any information, document, or other article that is or is intended to be for the purpose useful to an external force. So virtually any kind of even diplomatic work to try to gain information on the country that's hosting them. I mean, this kind of research, journalists are supposed to do research. Well, if social and economic development is also included as a national security area, and then any state secret on plans regarding social and economic development, you couldn't even talk about it. So again, this partakes of the same problem of the NSL vagueness. You and I don't know when we're crossing the line. So what do? We don't talk about it at all. We stay away. So that I think we talked about that earlier. And then they use the language with intent to endanger national security. Well, even the people convicted this week are accused of having the intent to endanger national security. The judge saying, even if they don't know they did it, they don't know they endangered national security, they have the intent to do it. So that is a breathtakingly vague notion that you just do it with intent to endanger national security when you don't know the boundary of national security. Sedition actually adopts, under the new Article 23 legislation, it adopts the colonial language of just causing hatred in society. Okay. So, if I make an argument with passion, will I cause hatred in society? I mean, politicians today are doing a lot of causing of hatred in society around the world. So that you can think of it in those terms. There's all this new language regulations relating to computers, which I think risk heightened surveillance. So what you download can get you in trouble. So what does this say to anyone traveling to Hong Kong? Well, in the old days, we used to say for people like academics and some business people, bring a burner phone, burner computer to Beijing. Now, this law seems to put us in a position where maybe that's the best advice when you go to Hong Kong. And in fact, some companies now are separating their computer structure so that the Hong Kong company is not inside the foreign company's home computer system, that it has a separate one, because they don't want any of that, all of that, to be attributed to the local guy at risk. Okay. Espionage provisions really seem to label normal investigations and diplomatic oversight as criminal, so that you take it for what it's worth. A lot of this stuff talks about collusion with external forces, and it appears to forbid any work with a foreign or international organization with political ends. What do we do as academics? I mean, even if you have an institute at your university, can you host Hong Kongers? If that institute is focused on, say, political change, democracy, development, whatever, is there a risk to them to be working with your organization? I mean, we don't know. Again, the vagueness element kicks in. I found it very interesting in the consultation document that they have language where they say anybody who takes these kinds of actions under the guises of fighting for human rights or monitoring human rights. So fighting for human rights and monitoring human rights are guises. They're not genuine. So what it seems to suggest with all of this espionage and collusion and vagueness and sabotage, that basically human rights advocacy can be illegal. And I think that's the kicker at the end of it all. So the change, the difference between the 2003 bill and the current one is breathtaking.
Speaking of this issue of collusion with external forces, it seems like part of the current crackdown is aimed at simultaneously isolating Hong Kong activists from their overseas counterparts, while also engaging in transnational repression. So can you say a bit more about the international dimensions of the crackdown as well?
Yeah, it's very obvious, and of course we know the bounties on 13 and warrants. we're again another vagueness element here, because we don't know who else is being targeted other than those who have been named. But we know that many people who have not been named are probably doing the same kind of human rights advocacy as those who have been. So we don't know. I don't know if I could go back to Hong Kong. You probably don't know if you could go back to Hong Kong. So this is a sort of the design of the whole thing of international repression. And so I think what the new law does is, because you're supposed to report somebody who's engaged in treason or something. Well, you don't know what treason is. If you don't report them, then you can be sentenced to jail. So what it means is what they're trying to do here, and there's a huge element in the Article 23 legislation to target any support for overseas activists. And so they're trying to do is make it risky to communicate with them at all. by all of these provisions. And at the same time, we know from reports, I was just in the UK, and we know that there were arrests there of people charged with violating UK national security by targeting some of these overseas individuals in their surveillance and activities. One of the people arrested actually committed suicide afterwards. So it's a very high-profile matter in the UK that people like Nathan Law is mentioned in that particular case are being watched and surveilled by representatives of the Hong Kong government. And this has caused quite a scandal because they've traced money or something to the Hong Kong government and to officials in the office, the Economic Trade Office in London. And so there's now a movement by people concerned about it to actually shut down those economic trade offices for this reason, and also on a general principle that Hong Kong as an independent economic entity no longer exists because its autonomy has been totally degraded. So all of these things interact with each other, and the book tries to make sense out of all of that by drawing certain lines over time between what's happened.
Yeah. In the penultimate chapter, you talk about some of the steps taken internationally in support of Hong Kong, including in the US, the Hong Kong Human Rights and Democracy Act and the Hong Kong Autonomy Act, and scrutiny before the UN Human Rights Committee. What more do you think ought to be done?
I think there's a number of things that can be done. There's two fronts. One is, can you do anything to educate the Hong Kong government and the Beijing government on the consequences for all of these things, and maybe encourage change? On that front, the tools are rather weak. It's not a lot you can do, because when you try to use official pressure and you testify and parliamentary bodies issue reports and statements, the Beijing government just pushes back and a lot of it goes nowhere. I think one of the fronts, perhaps on that side of the equation, that is useful is some economic consequences for companies that participate in transnational repression in one form or another. So we know there are goods, for example, from repression of Uyghur people are blocked in trade and so on. And companies might find themselves running afoul of laws. But I think one of the things that could be done on that economic front would be to pass actual laws that sanction companies in criminal prosecution or otherwise if they engage in human rights violations or they participate in human rights violations. We know the United States, for example, has a law that prohibits corruption abroad, and it's a so-called RICO statute, and the companies that engage in corruption can be prosecuted if they engage in corruption overseas. It seems to me if one of the fundamental commitments of both the United States and the UK is international human rights, then why not have laws that do the same, that make it an offense to engage in human rights violations abroad? What we're doing now is sanctions, but targeted sanctions have had limited effect. But if companies are operating not just under a law that targets China, but a general law regarding human rights violations abroad, if they were subject either to lawsuit for violations or for prosecution, then I think countries trying to attract investments and participation by international companies would have a harder time, if human rights violations are involved. So I think a more general approach might be indicated now, given the experience that we've had so far. And Hong Kong government, we know, is like on overtime trying to attract international meetings and promote Hong Kong and all of this stuff, Well, the companies, if they have to be mindful of the human rights violations we're talking about, maybe that effort will be futile, and maybe that would persuade governments in Hong Kong and Beijing to change course in certain ways. So these are important things. And it's important to remember that every country that's a member of the UN is obligated to work towards human rights protection anywhere. A human rights violation anywhere is a violation everywhere. Every country is responsible to respond if you're a member. And of course, if you're a member of the multilateral human rights treaties, that responsibility even increases. So that's one side. The other side, I think, is how you deal with Hong Kongers who have fled Hong Kong and are living abroad. There's very serious problems for them because the economic needs they are not met because their license or something may take time to get qualified, maybe even have to go back to school and start over. So we've had a chance to meet with a lot of Hong Kongers in the UK and Ireland. And this has been a problem, but it's difficult when you're in exile to be an effective advocate for local political change, especially in an age when immigration itself is under attack. So it's a very difficult situation. And so international discussion and maybe encouragement of policies that are more conducive to the needs of exiles and refugees is important as a general matter. And in the case of Hong Kong, of course, the UK has a special responsibility. And I think it's unacceptable that some people in professions like social welfare work or lawyers or doctors can't get promptly qualified to participate because they already grew up under a system that was regulated by the UK. So their recognition of their professional qualifications should not be an issue, really, because they come from a UK regulated regime in the first place when they qualified for profession. So a lot of these kinds of things can be done to help deal with the exile community and help them, and even also to protect them from international repression and enable and assist their advocacy for change.
Right. Final question from me. You entitled the last section of your book, "Is Hope Lost?" Question mark. Are there any grounds for optimism regarding conditions in Hong Kong or in the Hong Kong diaspora?
It's sadly not a lot of grounds on the Hong Kong front at the moment. We are dealing in this case, of course, with what we're told is the second most wealthiest country on earth, I guess, in terms of overall wealth and power, maybe the second most powerful country on earth. And there's no signs at present that the Communist Party rule is changing its methods towards a more open and progressive form. In fact, it seems to be going in the opposite direction and under the current leadership. And so it's hard. There might be slight hope along the lines we just discussed, that if Hong Kong's economic agenda falters, maybe there could be some moderation or something. But my guess is that Beijing won't let Hong Kong's economy falter in any significant way. It could just replace international engagement with mainland engagement in Hong Kong. And so it is a difficult situation. For people in exile, they can't afford to lack hope, but the conditions are difficult at the moment. I can tell you from having met many people in that community, which we were meeting recently over 3 weeks in the UK, in the Midlands, and London. So the conditions are very difficult. And I think if this can be explained and effectively advocated, and we can effectively advocate change to make policies that assist them to qualify. I mean, a person with a university degree and a practicing social welfare person shouldn't have to go drive a truck when they move to the UK. They should be able to qualify in their profession. And so I think these are areas where a lot can be done, and hopefully in the democracies, people will listen.
Well, Professor Davis, not a very uplifting note, but that's the note we're ending on. Thank you very much for your time.
Thank you. So now, how do we stop recording? I don't even know. Let's see.